is contacting me.
All right, this is the People versus Christopher Moore. I have misdemeanor files 241722, 241589, 241136, and then we have a felony file. This is 241796 FY appearances.
Morning, Your Honor. Jeffrey Fanto on behalf of Mr. Moore. As to the state cases, we've waived formal reading, asked for warrants to be recalled. As of the city case, that's set for pre-trial 5th, and request would waive formal reading and stand move.
Okay, so as to 241796 FY, the felony case, this is a charge of home invasion, third, and domestic violence. Mr. Moore, you have the right to remain silent. Anything you say orally or in writing can and will be used against you in a court of law. You have the right to an attorney, and you have a right to have that attorney present during any future questioning and any future court hearings. In the event you can't afford an attorney, one will be appointed to represent you. You have 2 court dates within the next 21 days. Your first court date is your probable cause conference, which you can appear at via Zoom, and that is set for August 26th of 2024. Following that, on September 9th of 2024, you will have your preliminary examination. At that examination, the prosecutor will have to show that a crime was committed and probable cause exists to charge you with that crime. With respect to the remaining 3 cases, we have a State of Michigan versus Christopher Moore on 1136. State of Michigan versus Christopher Moore on 241589, and then we have a City of Taylor case 241722, and that's the B&E. As to all of those, the warrants have been set aside. They'll be set for pre-trials.
Judge, I would note that Moynihan is on. I would just ask that the 2 misdemeanor state cases be set for the 26th as well.
The misdemeanor state case be set for the, is the 26th, so that's a Monday?
That's the same day you set for the PISSY.
Oh, okay, so we'll just have them all?
The same parties.
All right.
Then the state, or the city case, I think is September 5th, if I'm not mistaken.
Yeah, there's a date of September 5th on that one. And then Ms. Moynihan, all 3 of the felony matters, then when we come in for the arraignment, or I'm sorry, the probable cause conference on August 26th, we'll just have those 2 misdemeanor files follow the felony. Now, as to bond. Ms. Moynihan, is there anything you have to say as to bond?
Yes, Your Honor. Thank you. Tina Moynihan on behalf of the people, P84-692. Judge, we were in court on Monday. I was there as the prosecutor covering the docket for Ms. Sobe and Ms. Davidova, and Mr. Moore was supposed to appear for an arraignment. He did appear by Zoom momentarily and then disappeared. He would not speak with Mr. Gizicki. With my understanding, Mr. Gizicki attempted to have conversations to proceed with the arraignment, and then Mr. Moore decided to log off before the case was ever called. My understanding, he then contacted the courthouse and spoke to a clerk downstairs and made threats to the court that if he came up to the courthouse that something was going to happen to people in the courthouse. And then it was also my understanding of speaking with the complainant who appeared by Zoom that there was an incident in the night prior, which would have been Sunday night. In that incident, Judge, there has been a warrant requested. I am in the process of reviewing that this morning. The allegations there are that the defendant broke into the complainant's home again overnight, forced his way into the home. He then adjusted cameras throughout the home that the complainant had so that he could not be observed. He's seen wearing all black, a hoodie, as well as a mask covering a portion of his face. He then enters the complainant's bedroom. He pulls a gun from his pocket and then shows that to the complainant, claiming that her fingerprints were on that gun and putting her in fear of an altercation ensuing. Further from that, he's then seen leaving the location by the complainant and heading out in an unknown direction. My understanding is that he's been staying across the street at the home across the street from her residence. And I believe that that is also going to be considered a violation of his bond that's been issued, that he's had no contact with the complainant, that he's not to return to that residence. And then there's allegations of new criminal activity. In addition, Judge, to his failure to stay in court until the case was called on Monday, I do believe that Mr. Moore is a danger to the complainant as well as to the public as a whole. He shows a wholesome inability to comply with the court's orders. I would be asking for a $250,000 cash surety bond, no 10%, with a GPS tether and house arrest if he were to be released. And I would ask that there be a 2-mile radius from the complainant's residence so that he's not to return to that area.
Anything, Mr. Fanto?
Well, I guess we have allegations that I don't know that the court should take into consideration relative bond as these cases stand. However, I would note that Mr. Moore does have some serious medical issues. At least if we could mark the files medical so that Wayne County knows. He is on SSI.
Okay. I don't think there's, the things I'm to take into consideration is whether or not he's a danger to the community. He's a lengthy criminal history. His behavior in this court has been absolutely egregious. Since these cases have started, he has assaultive criminal convictions. He clearly does not have any issue ignoring court orders. He is certainly a danger to Miss Butcher as well as the community at large. He's certainly a flight risk. He was already in immediate warrant status on one of the domestic violence charges on August 5th when he failed to appear for court. We've had a separate case where he had an immediate bench warrant on 2 different dates, both June 13 and August 5th, for failing to appear at court. He's now got pending against 1 complaining witness, 2 domestic violence cases, 3 domestic violence cases, a B&E and a home invasion. There's an allegation that a firearm was used in one of those instances. There was a police report filed. Detectives had to come over to the court Monday after there were allegations that Mr. Moore called the court, was extremely volatile with court staff. And Ms. Moynihan, the language was that he was going to come up to the court and commit a massacre. That's the allegation of what he was screaming at court staff. So I have to agree with you entirely. Mr. Moore is a danger to the community. Mr. Moore is a flight risk. Mr. Moore has shown absolutely zero respect for the criminal justice system, the legal system, or the safety of his own child that resides with Ms. Butcher. He will have a $250,000 cash or surety bond with a GPS tether with a 2-mile radius of complaining witnesses home. The file will be marked medical. Mr. Moore, you're to appear in court as directed. You're not to leave the state without permission of the court. You're not to commit any new crimes while released. You're to immediately notify the court of change of address or phone number. You're to have no contact with Miss Butcher. And a matter of fact, you can't not only go to her home, you can't go on her street. Period. What's the address? You're not allowed to be on Wendy Street in Taylor. Period. These are on the felony case. These are the bond conditions set for 1796 FY. You are not to possess or have access to firearms. You cannot purchase or access or consume alcohol or illegal drugs. On misdemeanor, I've also signed the request for a court-appointed attorney to ensure that Mr. Moore has counsel at all future proceedings, and that's in the file. As to the 3 misdemeanor files, each of these files will have a $10,000 cash surety bond with a GPS.
Top of 250,000.
No, that's plus, so it's 280,000 altogether.
Hey, ma'am. If I can say something when you are done, please just let me know.
Mr. Moore.
Mr. Moore, you have a.
Prefer you not.
Yeah, Mr. Moore, you have a constitutional right to remain silent. Given the amount of hot water you're in right now, I would strongly encourage you to follow the advice of your counsel.
We've got pretrial services relative to the felony.
I will request a DSU report at counsel's request on the felony. Is there anything else?
Yes, can I say one thing, please?
Mr. Moore, your attorney is advising you not to say a thing.
I understand that. I'm asking, please. Would that be okay?
I would prefer you not, Mr. Moore.
I understand, I respect that, but this is my life in the balance and me ever seeing my kid. So I would like to say something. I understand what this looks like. I understand that you guys are upset. I understand that I didn't show up and advise to every court ruling because I've had bad experience with the judicial system. That's not an excuse, but at the same time, it is the truth of what I'm saying. I have documentation showing, and I've called the courts. I called the detective. I called the domestic violence. I recorded them. And,
Mr. Moore, listen. Mr. Moore, I
understand.
appreciate all of that. I want to be clear, given your history at this court and what's happened recently, there is absolutely nothing that you can say that will change my bond on this case. Nothing.
How about her conspiring to commit murder on me?
So
and I haven't
what
touched
will
her?
happen is your attorney has requested a DSU, and I've granted that DSU request. So the Michigan Department of Corrections will meet with you, and if they find a bond modification is appropriate, they will issue a recommendation to this court. I'm not so inclined, or I don't know that I would even necessarily follow their recommendation, but I will certainly look at it and take it into consideration.
Ask her
And I
what-
marked the file medical.
Thank you.
She don't have
All right.
but she's to a 1% of motorcycle club.
All right, thank you. We're all set. Thank you over at the jail.
Thank you.
Thank you, Judge.
All right, and do we have Mr. Llewellyn? He's back. on the phone.
I just wanted to let the court know that Mr. Moore would like another attorney. So we probably have to call and get him yet another attorney.
Can you handle the arraignment today?
Yeah, I can handle I'll do the arraignment, yes.
All right, I mean, he
Yes.
needs to be arraigned, and so, and then we'll let them know that we need yet another attorney.
Yes. I tried to explain to the client that I would schedule it with him so that we could talk at length, and that really upset him. I did explain that, I needed to go to the courtroom at this point and then speak with him on Zoom at a later date, but he wants another lawyer.
Okay, so let me call these the new one first. This is 241976 People versus Christopher Moore. So Mr. Moore, initially you had an attorney that was appointed through NDS, and they had the attorney they appointed was not I don't want to say qualified, but she didn't meet the standards under the Michigan Indigent Defense Commission's to handle a case of this nature. So she was removed from the case because she can't be on that list. Then Miss Watt was nice enough, kind enough today. She was called to stand in on this or come into the case forthwith so that you could have your court date. So I just want you to know what happened today. So now we have Miss Watt here. It was scheduled at 1:15. All we're handling today is the arraignment. So you're being arraigned on your new case. And I've known Miss Watt for many years. She is a very good defense attorney. And obviously those are decisions you can make, at least for the moment. But I am going to proceed with the arraignment. And then if you want different counsel, Miss Watt, it sounds like there's a breakdown.
Yes.
Okay. So Mr. Moore, on this case, Miss Watt, can I get your appearance for purposes of arraignment?
Yes.
If she's gonna be
Cora Watt, appearing on behalf of Christopher Moore, P41508.
Okay, so Mr. Moore, we can get you a new attorney if you want a new attorney, but I'm arraigning you on these charges.
Your
okay,
Honor,
well,
we stand mute to make the formal reading of the warrant on the charges, Your Honor.
Okay, so Mr. Moore, you have a right to remain silent. Anything you say orally or in writing can and will be used against you in a court of law. You have a right to an attorney, and you have a right to have that attorney present during any future questioning and any future court hearing. If you can't afford an attorney, one will be appointed to represent you, as Ms. Choate was, now Ms. Watt was. And it's my understanding now that, Mr. Moore, you want to fire Ms. Watt?
correction. I have witnesses in here. She was not listening to what I was finishing trying to say. I had to stop because somebody else, as you can see, there's other court proceedings going on here with several other judges, several other inmates. Got a basketball gym that we're holding court next to. I have cancer. I just had a seizure while I was in custody at Taylor PD when I was picked up. I was sat in the hospital for 4 days. I was trying to tell her, she's trying to present an argument, and I'm trying to get her to understand, but then she's saying that she didn't have the discovery package. This is all falling on the error of not myself. I'm just sitting here and I was explaining to her.
Okay, well, Mr. Moore, listen, Ms. Watt was appointed to your case 2 or 3 hours ago. So of course she doesn't have discovery. She was just appointed, and that's not her fault at all.
It's clearly not my fault, ma'am. I was asked a question and I was trying to
telling you. All right, Mr. Moore.
All I was simply asking, just let me know when I can speak, please. So we're not.
All right, well, you have 2 dates within the next 21 days. The first is your probable cause conference, which is set for September 4th of 2024. Following that, you will have a preliminary exam. You are to appear in person at that hearing, and that is September 9th of 2024. And we will get this back down and have another attorney appointed to represent you. Mr. Moore, are you telling me that there's been a breakdown between you and Ms. Watt that you believe affects her ability to represent you?
I didn't say anything. She said that she was going to go back into the courtroom. This is what she said. I didn't even say anything. She said she's going back in the courtroom. Oh, this ain't going to work. I was like, what's not going to work?
I don't speak like that, first of all, Your Honor.
All right. Well, let me ask you, Ms. Watt, instead of Mr. Moore, Ms. Watt, has there been a material breakdown where you can't represent him?
Yes, Your Honor.
All right. So you're being removed from the case.
Thank you, Your Honor.
But I'm setting bond on this case. Now, he currently has a $250,000 cash surety bond on his other home invasion case. This one is certainly even more concerning. So, because now he's gone to home invasion first.
Home invasion? What are you talking about? When did this happen, ma'am, Your Honor? Is there a date?
All right.
Mr. Moore.
Mr. Moore, listen. You know what, Ms. Watt? I don't want there to be any confusion or anyone to say nobody did their job. So here we go. The allegations are that the date of occurrence is August 12th, 2024. And the witnesses state that on the date at that location, the defendant, contrary to law, committed count 1, home invasion, did break and enter or did enter without permission a dwelling with the intent to commit an assault therein, and while entering, present in, or exiting the dwelling, and or was armed with a gun, a dangerous weapon, contrary to MCL 750-110A, parent 2. That is a felony punishable by up to 20 years in prison and a fine and or $5,000 fine. A consecutive sentence may be imposed for any other conviction arising out of the same transaction. Count 2 is weapons felony firearm. The allegation is that you did carry or have in your possession a firearm, to wit, a handgun, at the time you committed or attempted to commit a felony, home invasion first degree, contrary to 750-227B. That is a felony punishable by 2 years consecutively with and preceding any term of imprisonment imposed for the felony or attempted felony conviction. Mandatory forfeiture of the weapon or device. Count 3 is weapons, firearms, possession by prohibited person. The allegation is you did possess and or use a firearm when ineligible to do so because he or she had been convicted of assault with intent to do great bodily harm, less than murder, and or uttering and publishing an offense punishable by imprisonment for more than 1 year, and the requirements for regaining eligibility had not been met, contrary to MCL 750-224F, parent 6. That's a felony punishable by up to 6 years and or $5,000. Count 5 is assault with a dangerous weapon, felonious assault. And it alleges that you did make an assault upon, to wit, a handgun, but without intending to commit the crime of murder or to inflict great bodily harm less than the crime of murder, contrary to MCL 750.82. That is a felony punishable by 4 years and or $2,000. DNA to be taken upon arrest. A consecutive sentence may be imposed under MCL 750-506A if the assault was committed in a place of confinement. Count 8 is weapons felony firearm.
There's
the
no charges on this, ma'am?
I'm still reading your charges. We're on number 6.
I'm sorry. I didn't mean to interrupt you, ma'am.
All right, well, listen.
Okay.
You want to know, I'm telling you.
Yes, I wanted to know.
Did carry or have in his possession a firearm, to wit, a handgun, at the time he committed or attempted to commit a felony, to wit, assault with a dangerous weapon, contrary to MCL 750-227B. This is a felony punishable by 2 years consecutively with and preceding any term of imprisonment imposed for a felony or attempted felony conviction, mandatory forfeiture of the weapon or device. Count 7 is domestic violence. And the allegation is you did make an assault or an assault and battery upon individual with whom you have a child in common, contrary to 750-81, parent 2. This is a misdemeanor punishable by up to 93 days and or $500. A consecutive sentence may be imposed under MCL 750-506A if the assault was committed in a place of confinement. You are charged as a habitual offender, and there is a 4th offense notice on your information or complaint.
This was all on August 12th at what time, ma'am?
There's not a time on here. It said it's at August 12th at this location. No, I'm still reading, Mr. Moore.
There's more?
Take notice that the defendant was previously convicted of 3 or more felonies or attempts to commit felonies, in that on or about October 19th of 1995, he was convicted of the offense of stolen property, receiving and concealing in excess of $100 in violation of 750.535A in the Detroit Recorder's Court for Wayne County in the state of Michigan. Listen. And on or about 2/16 in 1996, he was convicted of the offense of breaking and entering a vehicle to steal property over $5 in violation of MCL 750.356A-B in Detroit Recorder's Court for Wayne County in the state of Michigan. And on or about December 9th of 1999, he was convicted of the offense of police officer fleeing 3rd degree in violation of MCL 750-479A3 in the 3rd Circuit Court in Wayne County in the state of Michigan. On or about 3/31 of 2000, he was convicted of the offense of assault with intent to do great bodily harm less than murder in violation of 750.84 in the 3rd Circuit Court for Wayne County in the state of Michigan. I'm not done. And on or about 4/26 of 2013, he was convicted of the offense of uttering and publishing in violation of 750259 in the 44th Circuit Court in Livingston County in the state of Michigan. Therefore, defendant is subject to the penalties provided by 769.12. The penalty is life if the primary offense has a penalty of 5 years or more, 15 years or less if the primary offense has a penalty of under 5 years. The maximum penalty cannot be less than the maximum term for the first conviction. So that is the information alleging all of the charges, or stating all the charges that you have, sir, as well as giving you notice of that fourth offender notice.
Oh, I'm sorry. Are you done? Ma'am. Your Honor.
Sir, I just want to remind you, Mr. Moore, we're not adjudicating this case today. Okay, this is not a trial. This is not a trial.
I didn't understand.
This is an arraignment. At an arraignment, you are to see and hear the charges against you, which I've now read into the record. And the other purpose is to set bond and notify you of your next court dates. It's not the date where I look at all the facts and the evidence and make any sort of determinations. Today is specifically
because these are all alleged.
Bond. What's that?
Because these are all alleged allegations, right?
Absolutely.
Okay. That's why I was asking you, because I was going to say on August 12th, there's no way that possibly happened.
All right, well, don't say any more. See, now you're trying to talk to me about the case.
That's why I asked you. That's why, okay, so don't say nothing now, because it's not the time to say it.
It is not the time, and anything you say can and will be used against you in court of law.
I'm not worried about it. I'm not lying about anything. I got nothing to lie about. So that's why I was just asking what it was. So for the record.
Oh, okay, so all right, so Mr. Moore, we'll get you a new attorney. The 2 misdemeanor cases are just going to follow the felony matters. So the 2 domestic violences will just go in and we'll work on those as your case proceeds through the 23rd District Court. You're to appear in court as directed. You're not to leave the state without permission of the court. You're not to commit any new crimes while released. You're to immediately notify the court of change of address or phone number. You're to have no contact.
So there's no way of being able to talk to my son in any way, shape, or form either.
Sure. Isn't the son at issue an infant?
He's 19 and a half months old.
Okay, then no, you can't. You cannot possess or purchase or consume alcohol or illegal drugs. You cannot possess or have access to firearms.
I ain't been able to do that for a long time, especially having a son. So
okay, so we already did a DSU referral. We don't have the report back, so we'll review all of this at that time. But your bond in this case is $250,000 cash or surety with GPS tether within 2 miles.
Okay, ma'am. Can I speak now, ma'am?
You have a right to remain. You can speak, but Mr. Moore, what I'm trying to explain to you, and I want to make sure you understand clearly, is you have a right not to speak. And any lawyer,
I know I would choose to speak. I was just trying to be respectful. Okay, I was trying to be respectful and not cutting you off. I was just waiting for my turn to say something.
Okay, go ahead. What do you want me to know?
Thank you. So, as I was trying to say in these alleged allegations, since I'm innocent until proven guilty, which unfortunately I don't feel like that's the case. However, I was just pointing out to the fact I need to have 2 biopsies and a colonoscopy. I don't know which treatment I can have in here due to cancer. Apparently now I had a seizure and I was hospitalized at Taylor Hospital, which is now known as Corwell Health, 3rd Medical Surgical East, where I had a seizure while being detained in Taylor PD.
Okay.
I have an abscess that's spread and the poison is spraying apparently in my jaw, going into my bloodstream as we speak. They're in the process of opening a new jail. I just went through my 4th round since the hospital of antibiotics. I'm developing an immunity. So they basically said, either the judge is going to either lower your bond or give you a personal bond and put you out on a tether, or we will when you turn around and either possibly.
Okay, well, I'll tell you what, I'll make sure I contact the Wayne County Jail and let them know that your bond is $250,000 cash and surety. I've marked your file medical, but I'll make sure that they know that you are not eligible for release on tether unless you post that bond. I'll make sure they're aware of that.
Well, ma'am, ain't that being a little biased and discriminatory?
No,
So
it's setting a reasonable bond on cases like you have pending. They're allegations, but I have an obligation to keep the community safe. And also, based on the prior lack of appearances, I also believe you're a flight risk. So those are the decisions that I've made. They are within my discretion, and I believe they are appropriate. So we'll see you on September 4th at your next court date. Thank you, Ms. Watt. We'll make sure we get a new attorney sworn in.
Thank you, Your Honor.
All right.